primary focus is to be looking at their recommendation. So I would say let's go ahead and just open it up for discussion.
Okay, thank you, Karen. We needed that start at the beginning. So we really appreciate everyone jumping on this extra meeting after last week's meeting to try and come up with some recommendations that we can present on Friday to the task force. And I wanted to go over, we have proposed language from the one recommendation we did at our first meeting, which is on mandatory robust racial equity training. And I have a draft language that if we could have an agreement on or edit it any way you would like, that would be fine. I'm sorry, I don't have a screen share, but basically the proposal that work group 3 would recommend that the work group 3 recommends that all court personnel be required to undergo continuing robust racial equity training as a matter of state employment. Training topics should include structural racism, implicit bias, and cultural awareness. Training programs should allow for periodic updates or refreshers. Personnel should include judges, public defenders, district attorneys, juvenile justice system staff, court staff, including clerks and magistrates, and probation officers. The task force also recommends jury education in the form of, in a video, the potential jury pool watches before jury selection begins. We recommend that the jury pool video explains to jurors the concept of racial bias and the need for jurors to be fair and impartial without racial bias. And there it is. So if you'd like a moment just to look at it, and then we could see if we have any edits, or we could have a vote to recommend this to the task force on Friday. Okay. Can we go back to our screen? Thank you. Anyone have any suggestions? I guess we can make a motion to adopt this recommendation to go to the task force.
So moved, Mr. Chair. Madam Chair.
Thank you, Senator.
Second, Madam Chair. Second.
Thank you, Commissioner Smith. So all those in favor, raise your hand or say aye.
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 And Tara, we can't see you, but we can hear you.
I'm video zoomed out today.
Okay. Are you in agreement?
Yes.
Okay, great. All right, thank you. That'll take care of that, and we will present that on Friday to the task force. So today we heard a lot of information last week, and after hearing from Jim and Danny and Amisha Cooper and Professor Smith, to take time to digest it, I believe everyone got the minutes from August 19th. And I thought I'd just go over kind of the highlights of what was discussed, what was talked about, and then some of the consensus, which I got most of your recommendations, and maybe we could go forward from there. But Jim Woodall started out with a great presentation on charging decisions and over prosecution of cases, as well as the over criminalization of our laws. And he talked about possible policy recommendations to deprioritize certain offenses, reminding us that most charging decisions are not made by the district attorney, but by law enforcement, who usually do not consult with the DA, and also magistrates and citizens' warrants. That pre-charging decisions can be impacted with diversion programs and deflect cases from the court process. That DAs should be guided by just, proper, equitable considerations, to stop multiple charges and look at options to break down from felonies to misdemeanors. Don't go for the highest level charges. He suggested we look at our drug laws and revise to stop disparities, racial disparities in charging, and the horizontal and vertical overcharging of cases. And also said this work group could consider status offenses, like the habitual status offenders. Danny Spiegel, who's here today and can follow up if we have any questions from the DA's office, spoke to us about the data needs, what goes into the plea bargaining, the Giglio police misconduct efforts, and it is the duty of prosecutors to hold law enforcement accountable. He explained how Durham DA's office is looking retroactively to see if there have been racial disparities in Superior Court pleas that are offered, to check for their own bias and hold prosecutors accountable. Danny spoke about mandatory minimums, sentencing enhancements like a possession of a firearm by a felon, drug charges within 1,000 feet of a school that we could consider, marijuana use, and that Blacks are 4 times more likely to be arrested than whites on marijuana charges. The Durham's efforts to use drug courts for high needs and not prosecute simple possession, but get treatments and services. Amisha Cooper from the Attorney General's office spoke about project overcriminalization and behaviors that do not jeopardize community safety, ordinances, city ordinances, or low-level misdemeanors, failure to return rental property, vagrancy, trespass, begging, housing code violations. And she is working on a report that should be coming out this fall about the overcriminalization. And then Professor Smith, who we really appreciate being here today to follow up on any questions we might have if we're making recommendations, gave us detailed information on the number of charges that we see in our system in 2019. Almost 2 million criminal offense charges came through the criminal justice system. 1.6 million are misdemeanors, and 1 million are traffic offenses. That 93% of the misdemeanors are nonviolent, and there are 10,000 ordinance charges each year in the state, such as sleeping in a park or begging, and that there are no services provided to get to the root behavior of the crime, but we are increasing people's criminal record histories with these city ordinances. She spoke about citations in lieu of arrest and told us about the citation project that 4 counties will begin and collect evidence to see if crime rises, that if arrests are not used in citations instead of the arrests, or summons instead of warrants, and that there's great variance statewide in how the process is done. I think Professor Smith said, you know, does this work group want to look to get the most bang for our buck? Because the misdemeanor system and traffic offenses account for most criminal charges in the state. Do we want to look at specific things within traffic offenses that are criminal, like expired registration, no insurance, revoked license that are not DWIs, window tinting, and also decriminalize class 3 misdemeanors to make them infractions? These were her not recommendations. This was information she was giving to us. And everything on an effort to save on collateral consequences of a criminal record. But I think one of the biggest things toward the end that I hope we can talk about, that we need good data on racial disparities, and that ACE system that is within the administrative office of the courts has racial data, that it's kind of buried deep into this massive amount of information, but it is accessible. We would probably learn a lot and justify many of our recommendations if we could have access to that racial data contained in the ACES system. I asked everyone if they could come up with some of the recommendations we could move forward after the presentations last week. So I think I would just stop there. Any additions or corrections of Jim or Danny or Professor Smith, I would welcome. And see if we can go forward with some recommendations. Don't be shy.
I'll start. I think one of the most logical and the simplest recommendations we could have is for first appearances on misdemeanors when people are in custody. We've been doing that here for a while. I don't see any reason why that couldn't be done statewide, and I think it really helps keep people from spending too much time in jail. So I think that's an easy one, at least in my mind.
Representative Moore, I think it's great to see so much consensus from your email from the folks on the work group. But for me, I think a really good starting point is just beginning with the basics, especially since we're looking at prosecutors, and that is reminding prosecutors across the state of their basic ethical duties and standards and obligations. I remember DA Woodall provided a standard from Washington, I believe is RCW 13.40.077 from the notes that I have here, because they serve as the gatekeepers. And again, I've said it before, I'm going to say it again. If prosecutors do what they're supposed to do, and they behave appropriately, are seeking justice, and being fair in their duties and obligations, we can avoid a lot of problem. So kind of like how we discussed the implicit biases trainings for our court partners. I don't know maybe the folks that are on the panel here today can help us, but figuring out a way to put that in good language where we remind DAs of their duties consistently, so they don't forget as public interest lawyers when they're so busy and doing the work that they do, already overworked.
And Senator, are you referencing the ABA standard?
I remember DA Woodall did mention the ABA standard. He also mentioned Washington State. I don't know, DA Woodall, you remember what I'm talking about?
Yeah. Washington State has a pretty comprehensive, I don't know, guideline for prosecutors. It kind of incorporates the ABA standard, but it goes even a little bit further than that. And I just thought it was a good guideline. Everybody in my office, we passed that around. Everybody liked it. Now I think there's merit in what you're recommending, and I think it would help if prosecutors had some guidelines that we could all look to, that we knew were recommended by the state at some level. I think it would be helpful.
I just think that if we start there, again, to my wonderful friends on this work group, I think it just solves a lot of the problems going downward. That as being the basic standing point. And I can tell you as an assistant public defender, DA Woodall knows this. When you're overworked and you're in this constant race of trying to get things done and accomplishing and making sure you're doing a solid job as well. The reality is people are human beings, and sometimes their own personal biases can kick in, and they might not do a thorough job as they could do. So I think that's something that is a critical component to the task force recommendation, figuring out a way to make sure our prosecutors across the state are looking at that consistently in order to perform their duties and obligations.
So Senator, would you be making a recommendation that DAs across the state use as a standard the ABA standards as well as Washington RCW 13?
RCW 13.40.077.
Anyone else like to discuss that?
I would completely agree, Senator. And as we were listening to Danny and DA Woodall's presentations last week on sort of the direction they have in their office as far as charging decisions and actually bringing a case, only bringing cases with, have met the standard of evidence forward. It was really positive to hear that's how you all run it, but scary to think that's not a standard across the state.
Okay, thank you. Commissioner Smith, do you have any questions? I think you're on mute, sir.
We'll go ahead and address what the senator was talking about there. I have no problem with that. I do have some concerns about when it comes with the ordinance in these local cities and local government. how they varies from place to place, and it's all depending on where you are and what you be charged for, and not knowing the laws. If things were a little more standard, it would make a lot more difference for people as they travel from place to place.
Sure.
But I didn't want to take away from what we're talking about right now, but that's what I'm going to talk about.
Thank you, Sharon. We will get to that shortly. But if anyone has, it sounds like we have a unanimous consensus.
Madam Chair, if Danny has any input or insights on some of those ethical obligations and standards and duties that he wants to share, I don't know if he has anything to share on the topic.
Sure. Yep. To that point, I would point out the Conference of District Attorneys does promulgate a handbook. I know multiple DAs. I'm sure DA Woodall could speak to that with more detail with his experience, but there is a good handbook that I certainly use and distribute to my new ADAs on my team that I think would be worth looking at. DA Woodall, you know the book I'm referring to in terms of the ethical responsibilities. I'm sure you're involved in that.
Yeah, I do. I think what this recommendation would take, as far as, giving it substance, would take a little bit of work on somebody's part, my part or someone's part, sort of put this together. I use the Washington Standard as an example, and we could do that. I don't think we could do that by Friday, but we could certainly have some recommendation concerning some statewide guidelines for prosecutors.
And again, Representative Moore, I don't think it's enough just to have a standard rule for folks just to look at. Like DA Woodall, you just talked about, it's going to require work. Just like we talked about in implicit bias training, there's got to be some sort of consistent training for prosecutors across the state to make sure that they're cognizant of their responsibilities and their duties, which folks can sometimes forget.
Yeah, I would think that's,
go ahead,
I
Danny.
would think that's just taking a good look at that handbook, which certainly has a lot more teeth and a lot more examples than rules you may see. I'm not familiar with the Washington rule. I'm not sure if I received that, but I would just state that I think it's about a 40-page handbook. It has several different hypotheticals, different kinds of conflicts that prosecutors can face, different kinds of ethical dilemmas. And I think it could be a useful starting point to think about how to add additional teeth and additional meat on those bones.
Yeah, I think one thing we might consider, I do think the Conference of DAs does a really good job of training. I think they do some of the best training I ever get. And I think the conference could, not only using that handbook, but maybe could develop some mandatory training for prosecutors along these lines. And that might be one of the recommendations that prosecutors have mandatory training in this area every year. And I think that the Conference of DAs would be happy to work on that. I do think the handbook's a great starting place for them, but we don't necessarily get trained specifically on that every year.
So Representative Moore, I think a good recommendation would probably be just to have some sort of ethical standards provided by the Conference of DAs yearly, based on some of the works that Danny spoke of and DA Woodall.
I would certainly echo what DA Woodall stated about first appearance. I know that wasn't discussed on the previous meeting, but I would absolutely support that. I think that would be a real substantive change. I practiced as a defense lawyer and a prosecutor in multiple jurisdictions, some of which did have first appearances for misdemeanors by policy. But as we all know, the statute does not require it. It only requires the first appearance for felonies and domestic violence matters and other kind of details. And I think, I'm not sure how far we should talk about that at this meeting, but I certainly think getting public defenders and lawyers into the process earlier and allowing that second look by a district court judge after the magistrate has given it their best shot would be a very substantive and real improvement to pretrial policies.
Okay.
Representative Maury, I want to make sure that you get a chance to weigh in. You've been facilitating, but I want to make sure that you get a chance to weigh in your opinion about the ethical standards for prosecutors as well as first appearance.
Thank you, Karen. Yeah, I'm totally on board. And I guess I would, we can present that the concept is for DAs to be trained and follow the ethical standards as set forward. And maybe Jim and the center can work on some of the specific language, but we can present that concept on Friday. And so with that, I think we're all in agreement. Let's go back to what Jim's recommendation that Danny spoke to about mandatory first appearances, which many jurisdictions do, but those that don't are not required to by our current statute. And people can sit in jail on $1,000 bond for a shoplifting until the officer's next court date. That's usually 30 days away. This was proposed legislation we had. It was never out of committee and judiciary. I'm fully supportive, and I think, would there be any further discussion on making mandatory first appearances for any criminal charge for someone who is held on a cash bond?
Can I offer, I don't want to take your time, but I wanted to, if it's possible, a couple of minutes on some thoughts about that based on projects that we've already worked on to do just that. I've worked in a couple jurisdictions that have decided to implement prompt first appearances where they previously weren't doing that. And just to make you aware, this is not, I think this is an important consideration. It's part of what allows the massive misdemeanor system to have such a derailing impact on people's lives when they get incarcerated for crimes that they couldn't get active time for, lose their jobs, lose their custody of their kids, face eviction, all those kinds of consequences just because they can't pay a bond and a judge hasn't reviewed their conditions. So it's an incredibly important issue. In some of our jurisdictions, district court is not held every day. In some of our jurisdictions, district court is held maybe every other week or once a week. And that creates real logistical problems with staff to have the capacity to do this. I worked in a 5-county district in 2019. They decided to do this. The most they could do in one of their areas was once a week, just simply because of the number of judges and opportunities for court. Another logistical challenge is that while some jurisdictions have county funding to do remote first appearances, which facilitates the process, providing the equipment in the courtroom is a county funded expenditure. And especially in the current environment, that potentially could be an issue. It's just, I'm just mentioning it as something in order to truly implement this. It's a consideration that folks might want to think about. The other thing that I'll mention is in the consent order in the Alamance County federal class action litigation, where Alamance County officials were sued over their local bail system. A consent order was entered in May of this year, and effective July 1st, one of the things that they agreed to, the judicial defendants, the Superior Court judge, the district court judge, the magistrates, and the sheriff, was that they were going to have first appearances within 48 hours. So the time matters. Some jurisdictions, it's once a week. Some it's every couple days. Some, it's 72 hours. In Alamance County, sort of that baseline that was accepted by the court is constitutionally valid was within 48 hours. Another thing is they don't have a public defender there. Those proceedings really are only meaningful if the defendant is represented by someone who both has had an opportunity to meet with them prior to the hearing and to receive from the district attorney the defendant's criminal history record so that they can effectively argue in court. In the jurisdictions that I worked with where we implemented prompt first appearances, the district attorney agreed to provide that information, and either the jail or in the courthouse, a location was set aside so that lawyers could meet with folks. Where there is no public defender district, as in Alamance, as in Judicial District 30B, where I work with stakeholders to do something similar, counsel was provided under contract through Indigent Defense Services. That, of course, costs money, though. This is not in any way to cast a rain cloud on the suggestion. I'm just mentioning these critical issues: timing, the availability of counsel, court schedulings, and the issue of physical equipment that if you think about and formulate, it could create a runway to having an effective rollout.
Thank you. Anyone else
Representative Mori, I appreciate Professor Smith's insight on that. Those are absolutely things that we need to look at. I'm sure a lot of the recommendations that our task force is going to recommend is going to require funding from our legislature. So that's obviously just something we need to make a note of and be cognizant of. But time is an issue, Professor Smith, and I think that's why we absolutely need to make this recommendation, because folks are losing their jobs, they're losing their housing. This is a race equity issue because we need to immediately get these folks in to a courtroom so they can get these bond hearings and to get these first appearances. So I think making a note about the costs and the need to provide that funding would be important with the recommendation.
Right. And Professor Smith brought up a component of this that I think has been discussed. Should there be a right to counsel for these class 3 misdemeanors? Should everyone have a right to counsel if their liberty is denied and they are in custody of a jail? For that first appearance, we used to always afford that opportunity for all defendants with class 3 misdemeanors. That was taken away. Would that be a companion recommendation to this?
Representative Mori, I think that's something that absolutely needs to be restored. I mean, I see it all the time. It's what leads to people getting criminal records because they're just quickly trying to get out of jail. So they oftentimes they go ahead and plead guilty to certain low-level charges just so they can get out. That's an injustice that we contributed to in the General Assembly. So hopefully we can restore right to counsel even for class 3 misdemeanors.
Any comment, objection?
I agree.
That's consistent with the recommendation of the NCC ALJ report that recommended that defendants have I can provide you with that documentation, a right to counsel anytime that they suffer a deprivation of liberty or significant collateral consequences.
I agree.
I agree.
All right. So with the caveat on the mandatory first appearances, taking into account some districts do not have district court, that there will be a possibility of a monetary infusion to make this possible, but we would ask for the mandatory first appearances for all held on any bond in detention, the next available district court date, or within 48 hours.
Representative Mori, my one concern now that I think about it is because I don't want folks to look at these task force recommendations and be like, well, we can't do these because it's going to cost money, right? We want to make sure that this task force is leading the conversation on this issue. I think it's important that the task force in their report provide some sort of disclaimer that, look, General Assembly, step up and provide funding for a lot of these recommendations. So I'm not quite sure because I'm concerned if we provide, look, with this recommendation, you need to make sure you provide money. Folks will automatically look at that and the recommendations are essentially ignored. That's my fear.
Right. Well, and you know, we could have our recommended guideline in 48 hours or the next session of district court. Kind of as a compromise. We're also going to be talking about bail pretrial. That may influence some of this at our next meeting.
Representative Mori, what about having a minimum 48-hour recommendation at least?
Our felonies are what, 96 hours?
Yes, I believe so. Yes.
If we have Christmas on a Friday,
Yeah.
you know, you're looking at a Sunday morning.
Representative Mori, I know it's going to be difficult to do a lot of these things, but again, our task force is making these recommendations, and just because something's difficult doesn't mean we shouldn't do it. Because at the end of the day, I mean, Henderson Hill talked about it when we had our roundtables and listening sessions. We've got to be able to aim high on our task force report because folks I know will water things down at the end of the day.
Okay. Sure, I'm all with you, believe me. I mean,
I know you are, Representative Mori. I know.
devil's advocate. We could say if it is a weekend or a holiday, the very next session. Otherwise, it's 48 hours. Some type of language like that.
Sounds good.
If you say 48 hours or the next regular session of district court, that should cover it.
Okay. Any other comments? Should we move on? Okay, who would like to go next?
I was mentioned earlier, if I may, Madam Chair, that I'm very much concerned about the ordinance in these different towns, and not making light of experience or anything like that when it comes to some of the local government, smaller towns. Sometimes they may not have the expertise or have the resources to really do a lot of studies as to what the effect on some of these ordinances. And sometimes what they do is they just adopt whatever they have next door, the city next door. And a lot of people are really getting into a lot of financial issues based on some of these ordinances. And sometimes you can ask the city manager or some of the elected officials, what does this really mean? And they really can't tell you, other than, you have to pay that fine or whatever the offense may be. Those things are very much concerning me from town to town and county to county, those type of ordinance.
Yes, sir. And there was legislation proposed on criminal law reform last session to do a study and require all local governments to send in a report and list all their local ordinances. That was not complete, but it was the same concern you had, from county to county, what are we looking at? Sleeping in a park may be a violation somewhere and not somewhere else. A curfew may be imposed somewhere. Is that a local ordinance? I know the League of Municipalities did raise a concern. They said, well, if you prohibit communities from doing local ordinances, how do you make sure no one's urinating in public or sleeping in the park, or what mechanism do you do to make sure your community is reflecting the values of the local governmental leaders? That came up. And Jesse, you may be able to tell us, do you have an estimate of how many different local ordinances there are across the state, even though we didn't have the complete inventory?
No, I can't give that to you. One of the problems that happened is that the local governments weren't even able to accurately report. In other words, so I went into the library, it was all filed with, I think it was a legislative division. I can't remember exactly where, but it's all this is public. And, I went in and looked at a couple jurisdictions who said, well, we didn't create any crimes by ordinances. And then I pulled their ordinances and saw, they've created 100 crimes by ordinances and didn't even know that they had created them. So the documentation is incomplete. It would require going through every local city and county ordinance to begin to count that. I will say that I know one of the concerns that was raised about uniformity, and there were some jurisdictions that raised a red flag about this, not that they're against uniformity, but once they became aware of the issue, I know I've worked with certain county commissioners about this, they wanted to decriminalize it, and they were afraid that if there was a push towards uniformity, they would then lose the ability to decriminalize ordinance crimes associated with poverty, homelessness, et cetera, because they would just become another state crime. So that's just a balancing in terms of how to treat this issue.
Jim, I think you had a recommendation about this. Do you want to present that?
Yeah, I mean, my thought, and I think this isn't an original thought, I've heard other people say this. You're going to always have a lot of pushback if you try to take local government's authority to enact ordinances away. That they're not going to like that. You're never going to get past that, I don't think. I've always thought the way to handle it is to have a sunset provision that sometime in the future, all local ordinances are null and void. So, but you have to now enact ordinances, beginning at some date that will continue to be in full force and effect, but your existing ordinances will not, so that they enact new ordinances under stricter guidelines than we have now. I mean, here locally, we have so many different ordinances. Believe it or not, it's crazy, and I don't think anybody ever goes to jail for this, but there's an ordinance in Orange County that if you kill a vertebrate, anything a vertebrate, it has to be reported to the county. So you run over a squirrel, who reports that? We joke we've assigned an assistant DA as the one who gets all those reports. But I mean, there's some really silly ordinances out there. And I've always thought if somehow we could wipe the slate clean and say, you know, what are the ordinances we really need? And let's decriminalize most of these, not give local governments the authority to criminalize most of them. We could clean it up. I mean, that's a lot of work. It's very complicated, but I do think we've got too many ordinances and too many of them are misdemeanors. Even class 3 misdemeanors can hurt someone on their record. So that's my thought, that you have a sunset provision and then new ordinances that are enacted go into effect once the sunset provision ends.
Representative Moore, my issue with these are, again, they're criminalizing poverty at the end of the day. Soliciting alms, public urination, right? Failure to pay fare. I mean, making those punitive, or even decriminalizing them, making them infractions. I mean, these folks that are in poverty, it's not like they're going to be able to pay these fines and fees anyways. I mean, we've got to be able to get these local governments to figure out a way to go ahead and get these ordinances off the book. And whether it's a sunset way that DA Woodall recommended, or look, a big bold push, hey, you need to make reforms and you got to get rid of these. But again, the fear is, what if the state begins to make these much more serious misdemeanors? I don't know. I don't know what a good way would be.
Tara, do you have a thought?
Sorry about that. I like DA Woodall's idea about the sunset provision. It seems like that would be at least a first step in terms of, you know, some of the just really outdated ordinances, just like wiping those off. And if they need to make it illegal to have a dog and heat outside again in 2021, they can bring it back.
Okay. The dog and heat proposal. Okay, so Jim wrote it down to a recommendation: pass a sunset provision for all local ordinances that are misdemeanors and establish stricter state guidelines for new ordinance enactments by local governments to standardize ordinances as much as possible and decriminalize as many as possible. Does that sound like a recommendation we could put forward?
Sound like a recommendation? Yes, ma'am.
Okay.
I'll support that.
Thank
Sounds
you.
good.
Sounds good. Sounds good to me. Recommendation number 3. All right, let's move on to another recommendation. And I believe, Tara, you may want to do this. I thought your recommendation that to establish a recodification commission, would you like to talk about that?
I think so. I had spoken with some people about that one. It's I think it's something that's really, really important, but it may be that this addressing this ordinances is more appropriate within the scope of this group, just because we're looking for, you know, real solutions soon. And I'm sure that the overly cumbersome and, you know, criminal code more disparately impacts people of color, but it's just a kind of a wonky argument to make. So I think one thing I would suggest in terms of overcriminalization would be addressing something Professor Smith mentioned in the last meeting, that AOC is not required to collect and produce in their annual tally report racial data. And that would really help us get a sense of what the disparities look like if we had that data.
Thank you. And I think that is a recommendation that we want to move to recommend that the tally report that is produced by the AOC, I'm not sure if it's every 6 months or it's an annual 12-month.
Annually.
Annually. That the tally report includes all racial data in the information, and that information right now is available to for-profit companies getting criminal records, but it's also only available, I guess, once it's reported annually, then to nonprofits like the School of Government. But everything we're talking about is based on racial inequities, and we need the data to show the racial inequities. Would there be any other part of this proposal, Tara, or anyone else, to make this a little tighter or inclusive of what is needed?
I know I'm late to the party. I don't want to cover territory that's already been covered, but I just was wondering if the task force has already considered sentencing commission. I must admit, I'm not familiar with the tally report, so I don't know how to compare that, but the sentencing commission also already provides some very good data in the way that it organizes by most serious charge. You can look at charge and ultimate conviction. It is also broken down by race. I was wondering if this group or other parts of the task force have discussed that as a possible area.
We have not yet, but I think we're looking at the early onset of the criminal justice system more than, you know, the end and the sentencing. So I think we're really looking, you know, like how many blacks versus whites get city ordinances? I mean, who is staying in jail disproportionately? Is it based on race? So I think part of this tally report shows all criminal charges, you know, the types of offenses. You need the racial information on that. Jesse, you want to add to any of this?
No, I would just say, I think Danny's right, and the Sentencing Commission is focused on charges that end in conviction, where of course a substantial number of charges are in fact dismissed. So, you know, if you are looking at the front where the contact with police is occurring, the opportunities for escalation, the opportunities for injury, for death, for pretrial incarceration, you know, for charges that may not even result in a finding of guilt, the tally report, and I believe I've shared it, Representative Moore, I'm happy to share another copy. It's a public document from the AOC, lists the count of charges, defendants, convictions for every single criminal offense that's charged in the calendar year. It's just one lens to look at the issue. There are other lenses to look at it, including exactly what Danny already mentioned.
Yeah, that's a great point in terms of dismissals and capturing other cases that don't ultimately wind their way through the system. I would simply argue that I think that the Sentencing Commission data is a relatively good proxy for prosecutorial discretion, given the vast majority of cases are resolved by plea, and you could always take out open pleas or jury trials. Actually, I'm not sure you could take out open pleas now that I think of it. It could be that you wouldn't necessarily capture all the judicial discretion that goes into that final analysis. But to the extent that they're agreed upon pleas, the Sentencing Commission would be a good way of capturing discretion in different ways, I think.
Do we have consensus that this would be our fourth recommendation for AOC to provide identifying racial information to be included annually in the tally report?
I agree.
A second.
Okay. Tara, does that kind of change a little bit your recommendation and satisfy you?
Yes, it does. Thank you.
Great. Thank you. Anyone else like to bring up a topic, or do you want me to keep going down our list?
Representative Moore, like I said at the beginning, I appreciate all your summary of all the recommendations. I think it's just great just to go down and hopefully include all those in our recommendations.
Okay. One recommendation that has come up by most everyone is to legalize or decriminalize simple possession of marijuana or drug paraphernalia associated with that. We have different proposals or ideas. Do we decriminalize, make it infractions? Do we legalize? That's on the table for a discussion now.
So Representative Moore, for me, I thought about this long and hard. And for me, I think the best solution, the forward-thinking solution that a number of states are already beginning to do is just go ahead and make a recommendation towards legalization based on the race equity lens that we're looking at. Legalizing and regulating marijuana is going to be able to create dedicated streams of funds for example, HBCUs, universal pre-K, grants for women and minority-owned businesses, supporting our court system, driver's license restorations, expungements, support for re-entry services, job incentive grants for folks that hire folks with criminal records. I think there's a lot of positive that we can do by doing that. And also at the same time, I believe Professor Smith talked about how a vast majority of the criminal charges that we do have are related to marijuana in North Carolina. So that could drastically reduce our caseloads as well.
Looking at what Professor Smith showed us, most commonly charged nonviolent, non-traffic misdemeanors in 2019. Number 3 was possession of up to 1/2 ounce of marijuana, 31,000 charges. Marijuana paraphernalia, another 30,000 charges. Possession of Schedule 6, another almost 13,000 charges. So, I mean, we're looking a lot of charges related to minor possessions of marijuana.
That's going to be able to solve a lot of issues if we simply legalize and regulate.
Are you calling for new taxes, Senator?
I mean, I'm talking about incentives for all of dedicated streams of income for a lot of the things that I just listed to you that we could have to support a lot of the work that we're doing, that this task force needs to do at the end of the day. Those wraparound services that counties and cities need. For example, when we talked about criminalizing poverty, I mean, those are resources that our local governments could use if we legalize and regulate it.
Commissioner Smith, any thoughts on that proposal?
I agree that if we would legalize marijuana, it would get rid of a lot of our issues. And not only that, as the senator just stated, that it'll bring in revenue, all sorts of revenue. Compared to a lot of states that have gone that way, I haven't read any lot of negative things that occur since they have legalized it. So I mean, there's so many states out there that we can piggyback off of, and look at the laws and things, and look at some data that already been set forth, and go from there.
Okay.
Yeah.
I agree. I support it.
I support legalizing marijuana, but I'm not sure that seems like there's a lot that would go into the regulation of marijuana, you know, if it's legalized. And believe it or not, this is something that a lot of farmers will support. We're seeing that with the hemp now, and we've got all the issues around testing marijuana right now. But I think at this point, this may be something that we need to keep here and fine tune a little bit more. I think this is more complicated than just a recommendation to legalize.
I agree. If I may say, I've talked to some of the farmers that are growing hemp, not marijuana, hemp, growing hemp. And because of the confusion as to a deputy sheriff trying to distinguish what's legal and what's not legal, and trying to figure that out, if it was legal, it would open the doors for some of these hemp farmers to go ahead and really use, it's a cash crop, but they're getting backlash on being able to move it from point A to point B, concern about law enforcement, and a lot of times law enforcement not aware of exactly how to figure out whether it's legal or not legal, whether hemp or marijuana. I have to say to the DA that there are some things that we got to really look at, but it will free up opportunity for some of these farmers that really want to get into it, have done a lot of research and what have you. And the feedback I'm getting is that they can't have a problem transporting it from point A to point B, afraid of law enforcement enforcing, thinking it's marijuana.
Representative Maury, I wanted to let you know that the staff is working on a research project related to this to sort of lay out the various models that the working group could consider. So perhaps one thing might be for us to continue that work and to provide it to the working group, and so that it could shape the recommendation more fully.
Thank you, Jasmine.
Representative Maury, I'm fine with continuing the conversation as far as legalization with respect to DA Woodall and what Ms. McGee just said, and figuring out the way to actually do it. But I think it's a good starting point to go ahead and make that recommendation. Not only will it generate, if we regulate it, not only would it generate revenue, it would save the state a ton of money. I want DA Woodall to prosecute serious crimes, like actual crimes, instead of having to use his DAs and staff on possession of marijuana, for example.
Yeah, we don't really, we don't prosecute them anymore.
Well, look, DA Woodall, you're doing that, but I'll tell you, in other jurisdictions, they are. And that's unnecessary use of.
Believe it or not, most local, at least here in my district, most local law enforcement agencies, they would agree with this.
Yeah.
But I do think it's something, I don't know how we handle this. I do think it's something we need to work on more. I think it's a little more complicated than just saying we recommend the legalization of marijuana. I think we've got to follow that up with some more substance, and I don't know that we've got that right now. I think that's something maybe Jasmine and the Attorney General's office could provide us with. And we're going to have other opportunities, I think, to make recommendations. I'm not trying to throw a damper on this one. I just think we need to look at it a little more carefully.
I would like to add also that I think the recommendation, it's not because of a possible revenue stream, it's the racial disparities in those charged and convicted. I think Danny said it was 4 times the number of blacks to white that got charged or convicted of marijuana. So Jasmine, would we be all right? This stays on the table, beef it up a little bit more with data and information before we make a final recommendation?
Sure.
Would that be okay with everyone?
Yeah.
Sarah,
Sounds good.
Yeah, I'm good with that. I'm good.
Yeah,
So-
that makes sense.
Okay, we will hold on that one. We have about 5 minutes. And I think 2 of the other recommendations that came up, or the discussion came up, was citations in lieu of arrest, or summons, not magistrate orders. And if we had any recommendations, there is the citation project that Jesse talked about, 4 counties looking to see if they did citations in lieu of arrest, would crime go up, that they will be studying that. They will have evidence-based after it. But as a work group to recommend to the task force that we would encourage the use of citations in lieu of arrest, and also watch the project to see how it goes, try to stop the variance statewide on, there's a wide variance of, how many citations are officers using versus arrests. Would that be a recommendation that we would have consensus on about supporting that project of citations in lieu of arrest?
Yes.
Yes, I support the recommendation.
Yes. I have a question. I agree with that. I have a quick question on hiring a magistrate. How did that, who recommend these individuals? Where do we pull these individuals from? What are their background and what they must or should have? I'm asking this to anyone that may know more about than I did.
Ronnie, the people apply to the clerk of court, The clerk sends all applications up to the chief district court judge
Okay.
across the state. The chief district court judge usually reviews them, offers them, and then they are supervised. Well, the Superior Court judge signs off on it, and then they are supervised by the chief district court judges. So it's any really interested people, they see an opening comes up, they apply through the clerk. Finally, they're offered the position by the Superior Court judge, and then the chief district court judge supervises.
So back to, in other words, they have their criteria of what they're looking for as far as background.
Yes, sir.
Okay, thank you.
Not all are lawyers. Many are lawyers. We don't have a standardization of magistrate qualifications in North Carolina. In Durham, about half of ours were lawyers, half were not.
Thank you.
Representative Moria, I would like to include as a recommendation encouraging the use of diversion practices by law enforcement and DA offices for criminal charges. I think that's critical. Again, I think Professor Smith talked about what 1.6 million charges were misdemeanor charges in North Carolina. A lot of those could be diverted if DA's offices looked at those in the interest of justice and law enforcement. If we had well-designed programs, especially to reduce recidivism and reoffending. And one of the biggest things I want to make sure that is never a barrier, I think I mentioned this to your email, was costs of any type of programs that would lead to diversion for an individual being indigent. I think that'd be a huge way to reduce the number of criminal charges that we would have in our court system.
Okay, and I'll get to that in 1 second. Do we all have an agreement on supporting this project of citations in lieu of arrest and watching this project being
Yeah.
done?
Yes, yes.
Yes.
All right, and thank you, Senator.
Sorry about that, Representative Moore.
No, no. Your recommendation was to encourage the policy for diversion practice with law enforcement and DAs in lieu of criminal charges with no
Yes,
indigent.
yes, yes. And I don't think that should just be for minor offenses, even if it was a much more serious offense. Again, I think prosecutors need to look at everything case by case based on the facts and circumstances. And it might be a serious charge, but at the end of the day, if it could be diverted based on the circumstances, based on the individual, then that's something that should be encouraged instead of causing more problems in our justice system.
Okay, we will not put in types of crime. We will just
No,
say
no,
criminal charges.
criminal charges.
Do we have consensus on that?
Yep, it's good.
Any objection?
Yes.
Tara?
Sounds good to me.
Okay, that's what we need to hear. We are now at 5 o'clock. We said this would be an hour. I think we've made a lot of progress, and we have at least 5 recommendations and our original ones, 6 recommendations. We're going to hold off on the Schedule 6. Is there anything else we have not? Well, the habitual status offenses. I don't know if we want to wait on that, talk about it next time in terms of over criminalization or any other issues you would all like to bring up.
Yeah, I would say just table that only because I think that gets complicated and you've not only got to make a general recommendation, you have to be a bit specific on that one.
Sounds good. Anything else we have not tackled that we were hoping to get to today?
I think maybe traffic offenses were mentioned. So again,
Yes, and I think that's what I was asking Tara, to look at the traffic offenses. I mean, we could pull out certain ones to say, should, expired registration be a criminal offense or an infraction? But that might be her recommendation for the recodification commission to review traffic offenses.
I think, yeah, I mean, the recodification commission could certainly be appropriate place to review that.
Or do we need a commission? Do we recommend these? Once again, what is safety? Is speeding safety? Should, if you're going 30 miles over the speed limit in an 80 or 70 mile an hour zone, that may get to public safety. So would it go to a commission, or we would come back and look at some of these highly charged?
Representative Morris, apologies for interrupting. I wanted to also just remind the group about Amisha Cooper's project, and it could be that you split the difference and that perhaps some of the work that she presents could I know we're not saying low-hanging fruit all the time anymore, but could present some areas for immediate action in combination with some longer-term action.
That's excellent. We could recommend to support the Attorney General's project with Amisha Cooper on over-criminalization. Specifically looking to reclassify traffic offenses that do not impact public safety. Good.
That sounds good to me.
Okay.
Yeah, I'm fine with that.
That's good.
I mean, you know who always objects to that?
Good.
Defense lawyers in rural counties.
And once again, we'd like the racial data if we can have that to show who's being charged, who isn't with these traffic offenses.
Absolutely.
Great. Thanks a lot for that, Jasmine. Have we missed anyone? Has anyone not been heard? Anyone care to make any comments?
Good.
Okay.
Good.
It's Josh Stein. I just want to say how impressive y'all are. Awesome.
We like
Represent-
all in this group.
No messing in this group.
Representative Mori, one thing that I would think that we should, maybe this is for another time to discuss, is look at, I know some states are looking at second look legislation where prosecutors' offices across the country are looking at re-examining folks that have been sentenced for criminal charges and they're sitting in prison for more than 10 years. And to see if they can some sort of way commute those sentences, or reduce them in any way to return them to the community. But that's something that I think we should examine, especially if it's been quite some time since that individual has been convicted and has paid its debt to society.
That may be a lot of what Work Group 4 is charged with.
That's
Okay.
right.
Okay.
But I would encourage you to talk to Henderson Hill, who's chairing that work group.
Okay. Thank you, Representative Mori.
Thank you. Okay, thank you, everyone. Justice Earls, any comment, or Attorney General?
I would just say that when you report on Friday, you can also talk about the things that you're still looking at, as well as all these amazing recommendations,
Okay.
to give other folks a heads up and give them a chance to, have input if they want.
I will try and write these down, send them out to our working group, make sure I have the language as best as I can. Please send it back or edit if you like. So we will see you on Friday then. Thank you.
Thank you, everyone. Thank you, Representative Mori.
Thank you.